Hello again, everyone. It's RobbRyder. This would be Sunday, February 15th, 2015. And today it's about the county treasurer, as CPA is DOA. And can you say malpractice? Turns out you want to be a CPA, you got to be licensed. And the treasurer of the county is a CPA. So he has to have a license. And that license has to have a particular name on it. And if he isn't using that name, well, maybe we can take it to his licensing board. Not that much different than trying it with the attorneys, with the CPAs. And then thinking it through a little further, there's a number of other people that need to have licenses. People that have to do with title insurance, people that have to do with real estate, loan originators, right? Banking, finance, that kind of stuff. And so are these people that we think that we've been involved in with some kind of contract, are they using the name that allows them to practice whatever their profession is? Or are they using a name with an initial instead of the middle name, which is usually what the case is? And then we could say, well, that isn't the same person. That's not the name on the license. Show me your license. They don't match. Not the same. Court of record would say, right, that's the unauthorized practice of, by whoever, isn't using the name that's on the license. So you can't use an initial in place of a full name. Right, that's my story. I'm sticking to it. They're going to have to prove me wrong. I don't care what they say. Let's go to court. Let's go do the thing the way it's supposed to be done and see what happens. So we're going to look and see that the county treasurer isn't using the name that's on a CPA license. And so they have a complaint form to fill out for CPAs, and I was mentioning this to Ro. It didn't take her 3-4 hours. She already had the complaint done, sent it out against her county treasurer. So, and then we're going to look at, there's actually 2 federal courts, right? If you look at enough paperwork, you'll eventually see, hey, look what they're doing. Hey, look what they're doing. Duh, yeah, they're using 2 different names. Not that much different than what they're doing at the local level, as I've shown numerous times in Roe's case, where there's the 4 court, the circuit court for the 16th Judicial Circuit, and the circuit court in the 16th Judicial Circuit. Both kinds of paperwork in the same court case. Well, I'm afraid those are 2 different courts. They're 2 different names for the court. And then the county and third-party administrators. Some interesting little pieces of paper of, little facts that I have found along the way that don't fit anywhere else except to say, hey, when I do a video, I want to point this out to somebody. So that's what we're going to do. As usual, if you can donate, I could always use it. PayPal is Ashley Rytlewski, ASHLEYRYTLEWSKI @gmail.com. Or you can do it the old-fashioned way, by the mail, to Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. And my email is courtofrecord@AOL.com. And my phone number is 616-712-6179. Okay, let's see where we go from here. First thing I want to do is just really quick. My last video, and I can never remember what I call these things, so you'd have to go look by upload date. So the one before this, last weekend, we were looking at Roe's case and the fact that in her case now a notice to appear has been issued to the lady that originated the complaint, supposedly against Roe, for disorderly conduct. That lady would be the county recorder, an officer of the county, who now has to appear and do a criminal case. Right? If they don't show up, well, I guess that's like we could say that that's failure to appear, and they can arrest you for that. But what I wanted to show, so that had all happened even before last week's video, but since I did the video, there used to be bond information over here on her case. It was up over 900, and like 80 had been used, and 575 have been refunded, and there was 200 and some dollars down here, and well, now they're all zeros. It's like there's no bonds in this case anymore. What do you think that means? So we're not done with her case. We found a couple of things that we've tried, and if I don't get them in this video, because I was going to talk more about the county stuff, we just have to see how it works. Okay, so you got a guy in your county, looks something like this: the Kane County Treasurer, David J. Rickert, CPA. He's advertising that he's a CPA. Let's remember that. And he's also the Kane County Treasurer. Okay, well, what about that? Well, every state, I would have to assume, has got something similar to the Illinois Department of Financial and Professional Regulation. Some things you have to have a license for, and well, being a CPA is one of them. And if we go to, I can get rid of some of this stuff now. So if I go here and then I go to somewhere down here, I should be able to. This is the home page. Let's get to the home page. Yep, home page. License lookup. Here we go. Go to license lookup and blah, blah, blah. Please note our license lookup for has changed. Oh, God, why they change stuff? Okay, well, just click on something and see where we go. Ah, that's where we wanted to go. Okay, so what is his name again? R-I-C-K-E-R-T, David. So you put his last name in. R-I-C-K-E-R-T. D-A-V-I-D. And looky here, detail. Well, his name is David James Rickert. And he's a licensed certified public accountant. And there's his license number. So David James is licensed. But that doesn't mean that David J is. David J. Rickert isn't David James. So he's advertising being a CPA without a license. The same thing that we talked about with attorneys. It's really the exact same thing. Except they have, so there's a different place for you to complain. Now, thinking of that, when I was looking at this earlier, because you have to have a license to practice law, and they have a whole bunch of different lists of names of things that need licenses. And so, counselor, professional, licensed is one of them. I said, you know what, that really sounds like that could be an attorney, because they don't have a listing for an attorney, by attorney. But on their license, they're licensed as an attorney and counselor at law. So we've been trying to go, to the way that we should be through the ARDC, the Attorney Registration Disciplinary Commission, blah, blah, blah. And they all, they say, we don't see anything wrong with this. And, you know that they do. And, but they're sticking, they're going to stick to their story. So, we'll find out eventually if this counselor professional license is the same as where you can turn an attorney in. But then loan originators need licenses, and all these different real estate agencies do, and title insurance agencies and agents. And that's all really important stuff, because, this is where you go complain to when you don't get the satisfaction you're looking for. It's why we've not necessarily exhausted our administrative remedies. So, well, it's just that clear that David James Rickert, he is a CPA, but David J. Rickert isn't. And so David J. Rickert got a complaint filed against him for the authorized practice of being a CPA. And we'll look a little bit into that. So, right, he didn't have, so there was a place for a DBA, or also known as, and he didn't put David J. He could have put it there. It'd probably been okay. But it's blank. Has a license number, active, says where it lives, yada yada. In 2006, it became law that in order for anyone to hold themselves out as a CPA to the public in Illinois, they must have an active license or registration with the Illinois Department of Finance and Professional Regulation, the licensing body for CPAs in Illinois. Anyone attaining the CPA credential after June 30, 2012 is required to obtain a CPA license, as the registered CPA category is no longer available for new applicants. Okay, so they still have this one called registered. They're getting rid of it, and they're just going to have licensed. And licensed CPAs may use the CPA designation, can't perform accounting, blah, 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 blah. Okay, and did it say if he was licensed or not? Well, it says licensee's name, so it didn't say registered. Yeah, he's got a license. There you go. He's not registered, he's licensed. An individual license and license for all firms are required. An individual's license, this is the same as for attorney firms, is all that is required for a sole practitioner, unless a firm name suggests the firm consists of more than one person, such as associates and company. Okay. So, if you're going to have a firm and call it a CPA firm, the firm needs to be registered. If you're a sole practitioner and call yourself a CPA, then you need to be registered. But if the firm is registered and you're part of the firm, then you need to be registered. So the individual always needs to be registered, and the entity that he works for or with needs to be determined. So I would say that since he's a CPA and the county treasurer, that the county treasurer is supposed to be registered. Because Kane County Treasurer, that's not the county of Kane, that's not the government, right? Kane County is a vendor, state vendor, or it's a vendor to the state, basically. And we'll be looking at that, hopefully, if I remember to show that. How they're actually using the EIN number of the county of Kane, yet representing themselves as Kane County, state vendor to the state. And getting, grants and all sorts of things. New applications for registered CPAs are closed. Okay, find a CPA license. We did. And, all right, this is what it says on the Kane County site, David J. Rickert. And this is what it says on the state site, David James, licensed attorney. Okay, so a little bit of the law that goes with this. Licensed certified public accountant or licensed CPA means a person licensed under this act as a licensed certified public accountant. Well, that's simple enough. No person shall hold him or herself out to the public in the state in any manner by using the title certified public accountant, licensed certified public accountant, registered certified public accountant, or the abbreviation CPA. You get the idea. Can't use it if you're not one. Well, David J., middle initial, isn't one, and he is using it. And so, by God, they got a committee that watches over this stuff. And so you send your complaint to this centralized board, and then depending on what category it is, they have these other, like this is the particular Public Account Registration Licensing Committee. Made up of public accountants, probably. And they also, the Administrative Procedures Act is hereby expressly adopted and incorporated herein, as if all the provisions of that act were included in this act. And this is where we get into that, your administrative remedy, right? Because they have administrative hearings and yada, yada, yada. So, what this is doing is, by reference, it just put the whole administrative act into this law, so you don't need to go to court. You can go to the act, and you can quote things out of the Administrative Procedures Act. All right, say, so per the rule, because those are really the rules. It's an act. Violate an act, that's, like violating an act of Congress. That may be considered treason. For the purpose of this act, the notice required under something administrative procedures is deemed sufficient when mailed to the licensee's address or record. Okay. And so what is, well, you sign, affix, associate, yada, yada, yada. Well, does he ever do that? Does he ever advertise? That's what I want to look at. Does he ever advertise? Well, if you look at your property taxes, there it is. David J. Rickert, CPA. He's advertising as a CPA on your property taxes. And he's not a CPA. Forget anything about the Kane County Treasurer. He's not a CPA. David James is. This man don't have a license. He's assumed the identity. It's identity theft. Okay. Unlicensed practice, violation, civil penalty. Offering, attempting, or holding oneself out to practice as a licensed CPA or registered CPA in this state without being licensed or registered under this act or qualifying for the practice privilege set forth is prohibited. In addition to any other penalty provided by law, an individual or person violating subsection A or B of this section shall pay a civil penalty to the department in the amount of not to exceed $10,000 for each offense as determined by the department. The civil penalty shall be assessed by the department after a hearing is held in accordance with provisions set forth in this act regarding the provision of hearing for the discipline of a license. So I haven't read all the stuff that closely. I mean, I just found it myself, right? Most of the stuff I do a video on, I didn't know it existed a week before. It's what I read during the week, and I do videos on it, right? So I'm not an expert on this, but I can say, well, this looks pretty good, right? We want to say that he's not a CPA and see what they say. The department has the authority and the power to investigate any and all alleged improper use of certified public accountant title or CPA designation and any unlicensed activity. Well, by God, what would that be? That would be this. David J. Rickert, Kane County Treasury, taking your money as property taxes. He's not a CPA. He stole the identity. Secretary means Secretary of the Department of Finance and Professional Regulations. I guess that's what they're talking about. Okay. Complaint. The confidential all information collected by the department in the course of an examination or investigation of a licensee, registrant, applicant, included but not limited to any complaint against licensee or registrant filed with the department, and any information collected to investigate any such complaint shall be maintained for confidential, yada yada yada. Well, how do you do that? I think I think the easiest way is to do this. Complaint. CPA, Illinois. ILINO. File a complaint. Okay. How do we do that? Ah, there you go. Look at that. Department of Financial Professional Regulation, Division of Professional, yada yada. You could do it online, right? Professional's first name, professional's last name, or business or name of business, selected profession, yeah. Certified public accountant on here. Let's look. Let's to make sure we're in the right place. Well, there it is. Certified public accountant. They do have. And the firms. And if they're just registered. And if they have a sponsor. Describe your complaint. Boom. You're done. They also have a paper one you can get. So, yeah, you can. You certainly can complain against the... they have a way to complain. Powers and duties of the department. The department shall exercise the powers and duties prescribed by the Civil Administration Code of Illinois for the administration of licensing acts and shall exercise such other powers and duties as invested by this act. the department shall exercise the powers and duties prescribed by the Civil Administration Code of Illinois for the administration of licensing acts. Right? They're the police over the licensing acts. If somebody broke the licensing act, it's their job to prosecute it. So you got to take the complaint to them. It's your administrative remedy. We're going to have fun with this. Applications for licensure. A person or CPA firm that wishes to perform accounting activities in this state, as defined in paragraph 1 of some subsection of whatever, or use of the CPA title, shall make application to the department and shall pay the fee required by rule. County treasurer. Is it an accounting firm? Right? If is Kane County Treasurer, which is an office, but it's not an office of the government, because Kane County isn't the government. The county of Kane's the government. Kane County is a frickin' a for-profit company on top of a non-profit company, not-for-profit company, corporation. Right? So does it need to be? So does Kane County Treasurer, because this guy's a CPA doing CPA work as the Kane County Treasurer, right? He's not necessarily doing it in his own name. He's doing it as the Kane County Treasurer. Does Kane County Treasurer need to be registered as a CPA firm? We're going to ask the questions. The Social Security number on licensee application, in addition to any other information required to be contained in the application. Every application for original license under this act shall include the applicant's Social Security number. And why is that? Because the name on the Social Security number is your legal name. And that's the name that better be on the license. Grounds for discipline, license, or registration. The department may refuse to issue, renew, or revoke, reprimand, registration, or blah, 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 blah. So none of this goes to court that we're used to. This is all done administratively within the jurisdiction of this licensing department. For dishonesty, fraud, deceit, or gross negligence in the performance of services of a licensee or registrant or individual granted privileges under Section 5.2. Performance of any fraudulent act while holding a license or privilege issued under this act or prior law. Well, they're pretending to be the government. They've not been elected to any office. They don't have an official bond. They don't have an official oath. They haven't done anything proper to hold the office that they're claiming to hold, and that's usurpation of an office, and I would say that's fraud. And so, boom, if they're committing any kind of fraud, they can't be a CPA. Making or filing a report or record that the registrant or licensee knows to be false, willfully failing to file a report or record required by state, federal law, willfully impeding obstruction of filing, and I'd say this is what they're doing when they take your property. By a tax deed. Or just charging you frickin' property tax. That, somehow we're going to be able to make hay out of this, that we're going to say, well, according to this, you're guilty of that. I just ain't read it enough yet. Engaging in dishonorable, unethical, or unprofessional conduct of a character likely to deceive, defraud, or harm the public. Jeepers. I wonder if this covers, who else they got? So you got the treasurer, got an auditor. Who else you got that messes with your property? Do they all need to be CPAs? Solicitation of professional service by using false or misleading advertising to say that you're the county when you're not the county. Right? Going to the county treasurer's office because that's where it tells you to go to get somebody's bond information, and they tell you there they don't have it. Well, then you're not the frickin' treasurer of the county. So why are you charging me frickin' property taxes. Investigation. Notice hearing. The department may investigate the actions of an applicant, person, entity holding and claiming to hold a license. Well, that's what's going to happen to our friend David. It is already in. They're just waiting for Monday. With respect to a determination by peer review administrator. Okay, so the department may subpoena and bring before it any person to take oral or written testimony or compel the production of any book, paper. That sounds just like court to me. All right, a subpoena is a subpoena, If you don't answer a subpoena, you can be arrested. The secretary, any member of the committee designated by the secretary, certified shorthand reporter, or any other hearing officer appointed may administer oaths at the hearing. Well, my God, we're going to put you under oath too. Okay, so, here we go. Criminal penalties. So, each of the following acts perpetrated in the state of Illinois is a Class A misdemeanor. The practice of accountancy activities as defined in some paragraphs. In violation of provisions of the Act. In other words, you don't have the license. So you're guilty of, so if you don't have the license, it's a Class A misdemeanor. So we could take, again, this could go as a criminal complaint. I'm believing we mail it to the presiding judge of the county. He's the guy sitting over the county. And if not him, then it's a particular prosecutor in the prosecutor's office that prosecutes misdemeanors. Because this is a misdemeanor, so I want to point out a misdemeanor. Well, then I don't want to give it to just anybody at the county prosecutors. I want the county prosecutor that prosecutes misdemeanors to look at it. I'd say he's the expert. The practice of accountancy, okay, we got that. The use of the title, certified public accountant, right? Boom, if you're using those and you're not one, you're guilty of a crime. Class A misdemeanor. David J. Rickert, CPA, you ain't, and you are guilty of a misdemeanor. Well, now we'll see what they do with it, but, you know, I've got enough evidence. This, where are you? And this are enough evidence for me to say, hey, this guy is practicing without a license. Let's go put in a complaint. Well, I didn't even need to do it. I just told Ro about it, and she has already done it. That's wonderful. It's already in. Don't need to wait. That's what a blessing. Absolutely. Okay, give me just 1 second here. Alrighty. This is the website for the state of Illinois' Comptroller. They got interesting things on here. Let's go real quick and look at this thing called the ledger. If you go to ledger, you can go to find a state employee salary database. Okay, and then you can put in the employee's name, and if you put in flood, and come down here, there'll be a bunch of floods, and this is the one we want, Elizabeth. All right, so Elizabeth Flood, agency, Judicial, division, personal services, as an associate judge of circuit courts. So what this is saying is that the position of an associate judge of the circuit court is in a agency, and all agencies are under the executive branch, division of personal services. Well, that's where hookers are, man. They're personal service. Basically what we're dealing with. But it's not the judicial branch of the government. It's an agency. So it's all executive, right? So if these judges are under the executive branch in an agency called the Judicial Agency, Division of Personal Services, then where is the judicial branch of the government? That's the question to get answered, right? But I don't know who it is. So, anyways, and then so these are all the judges that are associate judges. And I don't know if circuit judges were in here or not. I can't say that I found them yet, but I did find associate judges. So they're definitely administrative. So that was just one thing, but let's go back. There's one other thing I wanted to show you, because it's all said and done. So, that did mean something way back then. If we went to someplace in here where you can go and revenues, funds, cash, check for cash, expenditures, vendor payments. Okay, vendor payments. Okay, so the Comptroller in Illinois is a constitutional office, and it took the place of the Auditor General. And the Auditor General went all the way back to the time of the Northwest Ordinance, before there were states. So we're going to find out that this Comptroller's got lots of power over lots of things, and I haven't found it yet to say, well, this is it, but I will. It's just a matter of time. But I can show you this. This is the W-9 we got for the County of Kane. Address, local government, and their numbers. And as I pointed out in other videos, if you were to really read what this says here, this certification, the signature of the U.S. person, what should really be here is a seal of the County of Kane, because that's the U.S. person, County of Kane, should be down here, and maybe by Erica M. Wagner, but this isn't Erica M. Wagner's number. This number is the County of Kane's number. But 366006-585. Let's see if I can remember that long enough to put it in. 366006-585. No, I don't remember it. Except here, it's called Kane County. So, a W-9 that was made out for the County of Kane is being used by an entity calling themselves Kane County. I believe that would be identity theft. And then this lists all the contracts that they're involved in. Boom. All these are contracts that this vendor, Kane County, is involved in. And so we've asked some pretty straightforward questions by a FOIA to the Comptroller's office by giving them this number and say, we want to have all the information you can give us off of this EIN number. Right? Especially, however, they registered with the state to become a vendor. How do they become a vendor? This is the next question. This is the vendor page, right? This is payments to a vendor. Vendor contracts. Well, how did they become a vendor in the first place? And you got all these contract numbers. Here's one for $40,000. I really don't know what any of this stuff means. Human services. But what I do know is it's not in the name of the County of Kane. It's in Kane County. Very strange. Okay, so we may want to be looking at, because this is the Auditor General, it's a constitutional office, it's going to have a lot of power, and I just really can't put my finger on what it is yet, but it's going to have something to do with that administrative rules and the fact that this is showing that these judges are state employees, well, who has jurisdiction over state employees? Because they're not in the judicial branch, it was the judicial department, agency. And so we're going to find out, well, where is this agency, and what other you got personal service in there. Who else is in there? Okay, one more second. I hope this works right. Okay, I'm bopping all over because I got all these little pieces I want to cover. So, one of the groups that has to have a license is people who have to do a title insurance. And you really, if you own property, you want to go find your damn title insurance paperwork. I pointed this out in numerous videos. No one ever seemed to do it or go follow through with it. So, yeah, what the fuck do I care? I'll just move on to something different. I don't have any property. But in here it says that there's certain covered risk. Covered risk are someone else owns or has an interest in your property, someone else has rights affecting your title, arising out of leases, contracts, or options, someone else claims rights affecting your title, arising out of forgery of impersonation, someone else has an easement on the land, someone else has right to limit your use of the land, your title is defective, any covered risk 1 through 6 occurring after the policy date. So if any of these things here happen after the policy date, well, then you're covered. That's number 7. So first of all, it covers before 1 through 6, and then number 7 says, and then if they happen afterwards, 1 through 6. Someone else has a lien on your title, including a mortgage, judgment, so forth and so on. Right? These are things that are covered. That someone else, that there's a mortgage on your title. Someone has an encumbrance on your title. All these things are covered. Covered for what? Well, it's their duty to defend against legal actions. So, probably getting a little bit too big, Bob. We will defend your title in any legal action, only as to the part of the action which is based on covered risk and which is not accepted or excluded from coverage of this policy. So if it's in the other side of covered risk, then it's covered. We will pay the cost, attorney's fees, and expenses we incur in that defense. We will not pay for any part of legal action which is not based on a covered risk. Okay. What's the covered risk? All of these are. Right? 14, 15, 16, 17, 18. There's 29 things, right, that are covered risk. And I do believe, I don't know if I can search this one this way or not, but if we were to find fee simple. Well, it's not that kind of form. I thought on this one it used the words fee simple, that's what your title was. But I don't really know. Because I had these other pages that were with it, right? This was, but this is like the cover page, right? And it has all these other things, exclusions, blah, 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 covered, blah, 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 blah. So you got title insurance. Well, if they decide they're not going to insure you, well, then you would take it to the licensing people for whoever the title insurance was and turn their ass in. Because this has got a big ass seal from the insurance company, been signed, countersigned. They agreed to defend your title. Right? They have a duty to defend your title. So now what you want is specific performance of a contract. You have a contract that they're supposed to defend your title. You don't want your $400 back or whatever you pay for insurance. No, go do your job. Defend my title. So I guess that's why I wanted to bring this up. I just think it's quite interesting. Yeah, this is where it said it. Taxes, any charge, covenants, terms. No. Does not insure against loss, damage, nor against cost, attorney's fees, or expenses arising for reasons. All recording data referred to. Right, but there was something about this Schedule B when we were looking at it that it really isn't what it talks about in here. And I did a video on this a long time ago. My main thing is I wanted to show this piece of paper to say, here is a title insurance policy. Title insurance people have to be licensed. We should look closer at that. And instead of worrying about taking them into court to fight your frickin' foreclosure, get the title insurance company to fight it for you. That's the point. Okay, that's the ticket. Let's move on. Moving on now, because I have a couple other interesting things that I needed to show you. Okay, indictment. Here we go. This is, I talked about this in a couple different videos where this lady's being, they want to put her in jail for 4.5, 5 years. And defendant information relative to a criminal action. Please remember criminal action, because there's really only one kind of action. It's a civil action. And it says so in the law. There is no criminal action. But it's much easier when we get to here. So on this one here, right? United States District Court for the Northern District of California. For the. Remember that. Because we get down here, it's United States District Court, Northern District of California. That's a different court. United States District Court, Northern District of California. That's like a proper name of some entity, right? It isn't the United States District Court for the Northern District of California. It's a different court. It's the same thing they're doing in Roe's case, where they have two different courts, the forecourt and the in-court circuit. In the circuit court for the 16th Judicial Circuit, and in the circuit court of the 16th Judicial Circuit, I think is how it's done. They use for and of. Here they don't use the words in between United States District Court. There is no for. But there sure is here. United States of America versus somebody else, right? Well, the United States of America is not the government. The style of the Confederacy, since the very first article of the very first Constitution, Articles of Confederation, says the style of this Confederacy shall be the United States of America, not United States of America. So what we had done, because she's doing some other things with other people, and I'm all for that. Try as many different things as you can. But what we had done was first of all we sent a letter, a judicial notice, to the attorney firm that was supposed to be her court-appointed counsel. There's that word counsel again. And the way it works, if you're appoint a court-appointed counsel, especially if it's let's say as an attorney firm, if a firm wants to be seen as an attorney firm, then the firm itself has to be registered, as do all the members that are part of that. Now, like the secretaries and stuff don't, but the office help doesn't. But if you're a partner or whatever, other than the accountant or something like that, I think it is, you have to be a practicing attorney. And then the the corporation, like Swanson's and McNamara LLP, well, they have to, every year, they have to register with somebody. And they don't do these things, right? And so I kind of pointed out in my last video. But so this is what we did the first time. We sent this to the attorney firm. And not that there's anything great, because they didn't pay much attention to it, so I wrote another piece of paper to the chief judge, but this is a basis of why we're doing this. So I, the young lady's name, appearing in proper person, and what I've learned about proper person now from Illinois, please write this down someplace, remember. In Illinois, if you want to be seen as a proper person, so it's probably everywhere, going to be the same, you need to put on every instrument you put in your name, address, and telephone number. Right? So put your full name. If you want to be seen as a proper person, don't use any damn initials. Put your full name. Right? Whatever your legal name is. So, Robert Allen Ritlewski. That's what I'm putting down. That's me. Okay, appearing in proper person, inform Edward William Swanson, who's like the chief, of this Swanson McNamara. Chief partner, or whatever you call it. An attorney licensed to practice law, that you and Swanson, the company, are court appointed as my attorney, and I demand you defend my... See, that's my problem. That should be my good name. I hope the sister checks my spelling, because I suck. Edward William Swanson, in your official capacity as an officer of the court, take judicial notice that my fundamental rights and liberties guaranteed by the Constitution and treaty have been violated, and your firm's appointment as my defense counsel established your fiduciary duty to me to see that I receive justice, a complete remedy in equity, and that those responsible for the malicious prosecution of my person answer for their crimes. Your express consent to be governed by the Supreme Court and its rules, procedures, summary judgment, and orders compels your compliance. However, if necessary, I will have the Solicitor General of the United States of America compel compliance as he sees just. So, why am I saying all this? Well, because the plaintiff in the case, or other action by reference, is not the government of the United States, nor is it a criminal matter. Take judicial notice, the organic laws found in the Articles of Confederation, Article 1, the style of this confederacy shall be the United States of America. So, United States of America doesn't make it. Plaintiff, United States of America is not the government. Proceedings are not in accordance with the federal rules of criminal procedure, because there is no sworn complaint, and the attorneys involved are engaged in the unauthorized practice of law, because they're not using the name on their license, not in their official capacity as an officer of the court. Instead, they have engaged in a simulated legal process using color of law in violation of numerous acts of Congress. Take judicial notice, it appears that the company has neglected to annually renew its certification as required by the State Bar of California rules, and any protection offered by proper registration is terminated. Partners of Swanson and McNamara are jointly and severally responsible for the continued crimes against humanity that I have been persecuted by. Severally for the continued crimes against humanity that I am persecuted by. Take judicial notice, Swanson, if you are unable or unwilling to provide me a complete remedy in equity, including the elimination of all civil disabilities, I am left with no choice but to take my grievances to the gatekeeper of the United States Supreme Court for his help in obtaining a writ of certiorari resulting in superintending control from the highest court in the land. Take judicial notice, I demand justice that you have 72 hours to provide me documentary evidence of your accomplishment of your duty to defend my good name to this email address. Under penalties of perjury, I declare that I have read the foregoing notice and demand, and the facts stated herein are true to the best of my knowledge and belief. Executed on your date, your name, your address, your phone number, and then you should probably put, because I've seen it other places where you're supposed to use it, if you'll accept service by email, say, and I accept service by email to this email address. So we sent this to the attorney firm. And, they emailed her back. They wanted her to call. They wanted her to talk to them. And they said, you signed a plea agreement. And, and she really didn't want to talk to him. I said, you don't need, I don't believe you need to. We're really doing this as a courtesy to them. so that we can say that we have done it in case we need to go to the next thing. And, apparently we had to. And what the next thing is now, in this case, was to try this. So we're going to send this to the Chief District Judge, directly to her chambers. Request for judicial notice and review by United States District Court for the Northern District of California in equity. Right? I want it to be in equity. I'm going to tell them I want it in equity. Venue is Oakland as regarding a case, and so Chief District Judge, for the people of God, and in His holy name, I, her name, in my proper person, accept your oath, bind you to it, and remind you of your fiduciary and supervisory duties. Please take judicial notice of the adjudicated facts in the foregoing proceeding, and notice issued to the court-appointed attorney's firm in this matter included for review. In your supervisory capacity, if the facts warrant, please order a judicial review for unconstitutional acts by those bound by oath as officers of the court to ensure equal protection under the law and render a complete remedy in equity for the victims of this simulated legal process that uses color law in violation of Constitution and treaty. Take judicial notice. The Articles of Confederation, Article 1, the style of the Confederacy shall be the United States of America. Take judicial notice that the plaintiff in this cause, United States of America, is not the government of the United States. It has no legal capacity to sue, and its claim asserted is unenforceable under the provisions of the statutes of fraud. Take judicial notice that the United States District Court is being used as part of a name and two entities for the United States or Northern District of California and Northern District of California minus for the, to conceal plaintiff's intent. Take judicial notice that there is only one style of action, a civil action, yet this proceeding alleges to be a criminal action in a court not of record. Take judicial notice that the counsel required to be authorized to practice law are not acting in their official capacity as officers of the court. They are not using the name found on the roll of attorneys, by whatever name they call the roll of attorneys, kept by the state Supreme Court and the firm appointed by the court, as defense counsel is not registered to practice law in accordance with established rules. Take judicial notice that the attorneys claiming to represent the government are not acting in their official capacity, for they are not using the name that they have registered with the state's Supreme Court. Take judicial notice these activities are in violation of the United States Supreme Court, of the state's Supreme Court rules, resulting in contempt of the state's Supreme Court by officers of said court, which could be construed as warring with the Constitution. Doesn't matter, this is a federal court. They need to register somewhere in the state to practice law, even if it's going to be in the federal court. So even the U.S. attorneys and so forth need to register somewhere within the state. Chief District Judge Phyllis J. Hamilton, with one voice the people of God have spoken, to enlighten your conscience and bring to light of day the evil deeds of the false accuser. The Father waits for your testimony. Under penalties of perjury, blah, 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 blah. Yes, get biblical with them, right? You be the widow. Keep going to the chief judge and demanding justice. That's my answer. I'm going to keep going and demanding justice, pointing out the evil deeds of the false accuser. I don't care what they say. So that went out, and I don't know, the judge might get it on Monday, Tuesday. But again, just going through real quick, right? So, United States District Court for the Northern District of California is one style of court. And this one is the one that goes to the chief judge, if I'm not mistaken. Well, I'm sure it is. But this one here, United States District Court, Northern District of California, Oakland Division, that's not the same court. I don't care what they say. Where's the for the? If the for the isn't in, then that's just one long name of a court. And these people acted as attorneys. Melinda Haag, United States Attorney. Well, that's not the name that's on Melinda Haag's. We'll look at that again. Right, so she has Melinda Haag, but on the bar website, it's Melinda Lee Haag. Right, U.S. Attorney's Office. But I'm looking at the State Bar of California's website, and here it says she's in the United States Attorney's Office. Right, Miranda Kane was another one. Well, her name is Miranda Beth Kane. Kelsey Stewart's another one, but it's Kelsey Ann Stewart. United States Attorney's Office. That's funny though, this one gal, she's involved, but she's with Munger, Tollins, and Olson. Now, how did she get herself involved in this mess? Oh, well, she stepped in the doo-doo. And here's William. And, so he's Edward William Swanson. And it was August Gugelman. Now it's August Paul Gugelman. Sometimes it would put like A. Paul Gugelman or August P. Gugelman or, things like that. But anyways, all these people are listed with the State Bar of California. And they're not using the name that's registered with the State Bar. No different than what the CPAs are doing. And again, there is a thing for, it doesn't say for attorneys, but it does say for licensed counselors. And if you read what these guys' licenses say, if we can call it a license, right, they're authorized to practice law, or they're authorized to practice as an attorney and counselor at law. Words to that effect. Right, so that's their license. So they're a licensed counselor, and by gosh, on the licensing site, there's a place for counselors licensed. So we might ask them about if we can't get them from the Supreme Court side, but I think we will when we find the right door. Okay, well that was interesting. What else was there? Give me just a second. I got a couple more things and it'll be done. But if I'm going to put piece parts together, let me put a couple more in. Be right back. All right. This is just a copy of the one-page complaint form that you could fill out. Illinois Department of Financial and Professional Regulation Complaint Claim Intake Report. Complainant's claim against the respondent. Complainant claims received by. Boom, you're done. That's all it takes. That's simple enough, right? So whatever it was exactly that Roe put in was based on this form or the one that we saw online. It's just the paper form. But a couple other things. This was somebody was asking about appointed assistant state attorneys on a FOIA. I found this FOIA and I was reading through it, and this is really interesting. So the lawyer, this is a guy that's going to be appointed. He's a private lawyer going to be appointed as an assistant state attorney. The lawyer shall promptly provide monthly a copy of his detailed billing statements describing the lawyer's services to the chief of the civil division of the state's attorney's office. Now that's what they have in Illinois. They have a thing called the state's attorney's office, right? So to the chief of the civil division of the state's attorney's office. Further, the lawyer shall provide the chief of the civil division of the Kane County state's attorney's office. Well, that's two different offices. One's the chief of the civil division of the Kane County state attorney's office, and the other one is the chief of the civil division of the state's attorney's office. And we need to go to the state's attorney's office, not to the Kane County State's Attorney's Office, because the Kane County doesn't exist. Kane County is not the government. It's, a fictional entity built on top of the government. It's a for-profit company involved in antitrust activity because it's acting like it's usurped the powers of the not-for-profit corporation, which is the government. And yeah, I know a government's a corporation. It's supposed to be. Corporations have existed for 1,000 years, 2,000 years. It's just a structure with offices. There's nothing wrong with a corporation. It's who's in the office that's the problem. And it really isn't the man that's in the office. It's the devil that's in the man. And so we need to be casting the devil out. And that's what this is really about. This really just comes down to good against evil. But finally, the lawyer shall provide reports upon request to claims 1. Now there it is, County of Kane. That's the one we're looking for. Claims 1, County of Kane's third-party administrator. So I need to do a little more research on who this third-party administrator is. But getting into that and looking around a little bit, I came across this more recent one where it was Kane County Government Center Procurement Purchasing Department, and they were going to do a contract with this service agreement is made between Kane County, not the government, the client, and authorized self-insured entity, and Kane Cochran Management Services, a Delaware corporation. This agreed between the parties here too as follows. The client hereby appoints, this company hereby agrees to serve as third-party administrator of the client's self-insurance program created and existing under State of Illinois' self-insurance regulations. If you got a complaint against the county, Kane County, you take it to these people. They're the claims administrator. Claims in compliance with best practices will manage and administer all claims of the client that occur during the period of this agreement. The claim payment shall be made, yada, yada, yada. But when you get in here someplace, it talks about having fraud detection expenses such as surveillance. Okay. Shoot, I didn't highlight the parts in here. But anyways, so to me, it says, okay, these people have been appointed to handle any claim that's brought against the government or against Kane County. Right? And so we're looking for their bonds and stuff, and they say they're self-insured. Well, these are the people managing it, right? So go here. Go to Kane and Cochran Management Services. Or find your version of this. But what this was, so what would this have been called? Approving third-party claims administration services. Agreement with Kane and Cochran Management Services. Whereas to protect the interests of Kane County, prompt and effective handling of property, casualty, general liability, automobile and workers' compensation, insurance claims are required, and a claim service agreement with these people needs to be in place for fiscal year 2014. Now, therefore, be it resolved by Kane County Board of Chairmen is authorized to enter into contract with these people to provide third-party claims administration services for all lines of insurance, including property, casualty, general. So you want to put a claim in against their insurance, here it is. Right? You're looking for the bond that they don't have, but Kane County's been insured. Go there and forget the fact that the treasurer is a Kane County treasurer. No, he's a dude with a CPA behind his name who doesn't have a license to be a CPA. And we'll see if that makes anything happen. Okay, so basically that was that apparently there's more than one state's attorney's office. although they don't act like there is. But apparently there is. Who's the chief of the civil division? So that so this is the great thing about doing this. So now we have a paragraph that says what it says, and we can do a FOIA back to the same agency and say, in Section 6, it talks about the chief of the civil division of the state's attorney's office. Please provide me his information. Right? That's a record. I need the record. Who's the man on record of holding the chief of the civil division of the state's attorney's office, and who's the man on record holding the office of chief of the civil division of the Kane County State's Attorney's Office? And who is County of Kane's third-party administrator? Because this is claims 1 is the County of Kane, right? This wasn't the County of Kane. In fact, where we did with them, this was Kane County, and this is a different corporation, right? Kane County is with Cannon Cochran Management Services. But at least when this was done, the County of Kane was with Claims 1, a different entity. And we're still kind of, this is all brand new this week. It's like, well, what do you do with this? Well, research. Okay, hang on, just one last. Okay. I've shown them numerous times, but in Illinois, they have a really good place to go. You can find all the Supreme Court rules, right? So really, these are court rules. We're just talking about court rules, not so much procedures as court rules. And one of these rules is Rule 191, proceedings under certain sections of the procedure, right? So it's going to incorporate these sections of the Code of Civil Procedures into this rule. But we're basing it on the rule, per the rule, per the rule, per the rule. Forget everything else, it's per the rule. So, per the rule, motions for summary judgments under some section of the code, or involuntary dismissal under another section of the code, must be filed before the last day, if any, set by the trial court for the filing of dispositive motions. Right, so until the court says you can't do it, you can. Affidavits in support of and in opposition to a motion of summary judgment under these Section 105 and involuntary dismissal 2619 provided under Sections 2.34301 shall be made in a personal knowledge of the defendants, blah 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 blah. Okay, so anyways, what we're going to do is we're going to see about, after looking at these, it was, 2619 sounds like the proper one to use. And in 2619 it says involuntary dismissal based upon certain defects or defenses. Defendant may, within time of pleading, file a motion for dismissal of a motion or for other appropriate relief, right? So not just dismissal or other appropriate relief, because I don't want it dismissed. I want a little bit more than dismissal. I want a complete remedy in equity. Upon any of the following grounds, if the grounds do not appear on the face of the pleading attack, the motion shall be supported by affidavit. Okay, that the court does not have jurisdiction in the subject matter of the action, provided the defect cannot be removed by transfer of the case to a court having jurisdiction. Well, I'll just tell you the ones we picked. We picked number 2. The plaintiff does not have a legal capacity to sue because, again, this is supposed to be a criminal case, and although this is in the state, not in the federal, right, it's not in the correct court for it to be criminal because the plaintiff isn't the government. In the federal, it would be the United States of America. In Illinois, it would be the people of the state of Illinois. And they use people of the state of Illinois. They don't have the, not the proper one, so the plaintiff does not have a legal capacity. that the action was not commenced within the time limited by law. Well, we could say that because there's another Supreme Court rule that says when you get one of these uniform traffic citations, that they have 48 hours to get it to the frickin' circuit court clerk, and they didn't. It didn't get filed till like 10 days after it was issued, so technically it was past the time due. That the claim asserted is unenforceable under the provisions of the statutes of fraud. Well, yeah, I'm saying it is fraud. I'm going to say they're not using the proper forms that simulate a legal process. That the claim asserted against the defendant is unenforceable because of his or her minority or disability. You could have picked that too. So I have a civil disability. Right? You're charging me in not my proper name. If I had a sui juris legal personality, I would be sued in my proper person. And when I look at the docket, it says Ritlewski, Robert Allen, and that ain't right. It's not my proper person. So we took this and we wrote this up for Roe. We're trying to put together all the little pieces that we found in their Supreme Court rules without me going back and finding every one of them. But one of them starts out here. The very first one, Rule 101, because this is the trial court and this is the of court. So in the circuit court of the 16th Judicial Circuit, Kane County, Illinois. Rule 101. The summons shall be issued under the seal of the court, tested in the name of the clerk, signed with his name. It shall be dated on the date it was issued, shall be directed to each defendant, and shall bear the address, telephone number of the plaintiff or his attorney. And if notice or service or notices of motions or filings by fax or mail transmission will be accepted, the telephone number needs to be on there. And then elsewhere it says, well, if you take it by email, to put your email address, right? But the point is, you need to put your name, your number, address, and telephone number. So, Road put her name here, her mailing address, and her phone number, right? And and as far as I'm concerned, that took care of the rule that we're talking about. So the Circuit Court of the 16th Judicial Circuit, Kane County, Illinois, is the court, and then we want it in Chancery, because that was another thing it said, that depending on the action that you're asking for, you need to say if it's in Chancery, in law, yada, yada, yada. Could have said in equity, maybe, but Chancery is equity. So, motion for involuntary dismissal in accordance with Illinois Supreme Court Rule 191. Right, Section 216, involuntary dismissal based on certain defects or defenses, where it says defendant may, within time of pleading, file a motion for dismissal of action or for other appropriate relief. It is my belief the court's inspection of the record and judicial review of it and the proceedings in this cause will find the plaintiff does not have a legal capacity to sue. Its claim asserted is unenforceable under the provisions of the statutes of fraud. Further, in accordance with Illinois Supreme Court Rule 101, I did not receive proper notice, a summons or complaint, nor agree to any waiver of service, and the complaint was not filed within the time limited by rule and law. In that time, I think it was 552 was actually the Supreme Court rule that talks about that. So I, Rosita, ask the court to restore my civil liberties and good name, ensure my registration as an elector where I reside, and other equitable relief. The court in good conscience believes just, including the prosecution of false accusers. And there's some certificate wording you're supposed to put on here. So I don't know exactly what it ended up looking like when Rose sent it, or did it, but we're going to do this like we did the take judicial notice, where she had mailed it to the chief judge and it was entered into the docket by another judge, the presiding judge. So we sent this to the presiding judge, and we're asking for involuntary dismissal. Well, basically we want to remedy inequity, right? If he's got any questions, he can call. Other equitable relief. I don't want it just dismissed. That's not good enough. That would have been okay if it had just been the beginning, but even then it isn't good enough, I guess, because what we need to do is if a false accuser is going to bring a claim, we need to have him charged with bringing a false claim. That's the only way they're ever going to stop. Unless we stop them, they're not going to stop. So, well, that's about it. But anyways, this is just based off of, these are the Supreme Court rules, and this particular one I was telling you about was down here, had to do with evidence or something. Let's see what section that was. You may find you may put like Arizona court rules with, we're getting close now. Summary judgments, motions for summary judgments, because that's really all this is. They're motion for a summary judgment based on the information you're going to give them. So you could give them an evidentiary affidavit and say, take judicial notice of the included affidavit, and point out by their rules what they're doing wrong. So, okay, well, hey, that's about it for today. I think I covered most everything, and not very well, because a lot of it's brand new to me, and I'm just getting it in my head, but I do know which direction we're going based on it, and we're going to go ask some more questions and find out if the treasurer, as a CPA, who you take the complaint to. So keep that one in mind. That's a biggie. Okay, y'all have a great day. See ya.